In recent years, the United Arab Emirates has developed a model of governance grounded in legal frameworks related to national security and counter-terrorism legislation, within which the boundary between security and civil liberties has become increasingly narrow. From the well-known UAE 94 case in 2012 to the collective trial referred to as UAE H4 in 2024, a consistent pattern of escalating restrictions on political, civic, and academic activities has emerged across the country. The 2014 counter-terrorism law grants the statewide authority to classify any form of dissent or public criticism as a threat to national sovereignty. As a result, numerous individuals and organizations have been placed on domestic terrorism lists in recent years, even though none of them appear on international watch lists, such as those of the United Nations Security Council or the European Union. In January 2025, the Cabinet's decision to designate 11 individuals and 8 companies as terrorist entities exemplified the extension of this approach into the economic and social spheres. Examination of prior cases indicates that several of those individuals had already been convicted in earlier mass trials on similar charges. Consequently, the issue of double jeopardy, being tried twice for the same offense, has become a significant legal concern in assessing the fairness of these proceedings. At the same time, the judicial structure of the UAE faces persistent challenges, including a lack of transparency, the direct appointment of judges by executive authorities, and limited access of defendants to independent legal counsel. Reports from international organizations, including United Nations Special Rapporteurs and Amnesty International, reveal that prolonged detention, solitary confinement, and enforced disappearance have become recurrent practices in the treatment of civil and human rights activists. Within this context, a 2025 report by the MENA Rights Group specifically addressed the misuse of counter-terrorism legislation across Middle Eastern states, including the UAE, emphasizing that overly broad definitions of terrorism have been transformed into instruments for curtailing civic participation. Furthermore, field and legal reports regarding the arrest of individuals beyond UAE borders, including in Lebanon and Yemen, demonstrate the expansion of what has been described as a pattern of transnational repression, in which the pursuit of political dissidents extends beyond national jurisdiction. In response to this trend, several exiled jurists and activists have highlighted its incompatibility with Article 27 of the UAE Constitution, which restricts the application of laws to acts committed after their enactment and prohibits retroactive prosecution. At the international level, human rights experts and monitoring bodies, including the US Department of State and the United Nations, have expressed concern over the legal and humanitarian implications of these policies. These entities have stressed that while states have the legitimate right to adopt security measures, such measures must remain proportionate, transparent, and consistent with international human rights obligations. The continued practice of long-term detention, the limitation of access to legal representation, and the opaque nature of judicial proceedings represent serious obstacles to meeting these standards. A broader analytical reading of the data suggests that the UAE's approach to counter-terrorism has, in practice, redefined the relationship between law and security. The use of security legislation to regulate social and political behavior has not only constrained civil society, but has also revived theoretical debates surrounding the notion of legal authoritarianism, a condition in which law becomes a mechanism for consolidating existing political order rather than ensuring justice or accountability.